Next, Funez-Ortiz v. McHenry. There were a handful of McHenry cases before Pam Bondi became our Attorney General. This one's it's out of the Fourth Circuit on February 4th, 2025. I won't go on and on about it, but this is an interesting one. It's a Salvadoran, it's a Honduran gang case. And amongst the many other things that happened to Mr. Funez-Ortiz is a group of gang members who had been persecuting him showed up to his house, and one of them was in a police uniform. And the immigration judge, let me just make sure. I believe the immigration judge granted his case. Yes. Well, the immigration judge denied, because I do believe he was a former gang member or gang affiliated or had some other issues. The immigration judge did grant CAT protection to him, torture convention protection, but the BIA reversed that.
Wow.
And in doing so, one of the things they said was that guy who should there was no showing that the Honduran government would acquiesce or consent to the torture as is required of the Convention Against Torture. And the fact that that guy was in a police uniform, that doesn't say much. That guy was just a gang member in a police uniform. The problem is the immigration judge kind of held otherwise. The immigration judge held either that guy had police connections because he said he did at the door, or he was police himself. Maybe that's wrong, maybe it's not, but there was the Board of Immigration Appeals is not allowed to just disagree.
Yeah.
With an immigration judge on fact-finding.
Usually it's clear the other way around. Usually it's against the immigrant where the judge makes a finding. They say, well, we can't touch the facts. And they can't Well,
maybe that's true. Maybe it's not. But, they are the more fun cases when this happens. I talk about them on the podcast. The First Circuit actually has a great standard for this, that in order to overturn, this is out of the First Circuit, in order to overturn a immigration judge on clear error review, the IJ's finding must smell like a 5-week-old dead fish. That's from the First Circuit. That's how bad it must reek. That's from the First Circuit. And so the Fourth Circuit isn't quite as colorful, but flat out, you can't reweigh evidence. Also, Oil tried to argue, well, the BIA was doing proper clear error review because as a government agency, they're entitled to a, quote, presumption of regularity, end quote, which with everything happening at the federal government right now is the height of chutzpah. But in any event, the Fourth Circuit's like, no, that's not a way that you can get around our review. We're reviewing whether standards of review were properly applied. There is no presumption of regularity. The BIA either did the right thing or they didn't do the right thing.